time at the state for a Soto. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Do you plan on reserving any time?
Yes, Your Honor, I would reserve 5 minutes for rebuttal.
Okay, very good. You'll note it's up there on the board. When it gets down to 5 minutes left on that top thing, that's when your rebuttal time will be starting.
Awesome.
The arguments are being recorded. Initially, please introduce yourself on the record when you come up to present. Please keep your voice up and remain behind the podium so that you can be heard and we can see you during that time. It's also important to check that not here today, that we can clearly hear you when you walk it, so please stay behind the podium. You should not use the name of children, minors, and victims during the argument. You may refer to them by initials or by a term like the child. The judge have read your brief and are ready to proceed when you are.
Thank you, Your Honor. May it please the court. Eric Levy on behalf of Keith Soto. And I do apologize. I had a nosebleed incident, so thank you for accommodating me. If it should get bad or start up again, I may have to dart out, but I hopefully not. Your Honors, this was an interesting case. There was an indictment based upon a drug deal gone bad where an individual lost his life. That alleged initially an aggravated murder A, murder B with the predicate offense of robberies, and murder B's and felonious assaults with murder B or the predicate of felonious assault. Ultimately, Mr. Soto was acquitted of all the robbery charges, the murder A, and was convicted of the felonious assaults as applicable, and the murder B with regard to the felonious assault. This really came down to an issue of the testimony of an accomplice DI and the testimony of Mr. Soto as to whether this was a felonious assault or whether this was an incident of self-defense. The jury had asked questions regarding self-defense when it was deliberating. They were told to refer back to the instructions on count 1. Ultimately, again, they came back acquitting him, my client, of the robberies, but convicting of the felonious assaults. The convictions were based mainly on the testimony of DI, who was an accomplice. For purposes of this appeal, while there are several assignments of error, it really breaks down to 2 issues, essentially. The first one being the credibility of the testimony, specifically DI, and the evidence, and the second being the failure to obtain evidence and to investigate. With regard to the first issue, it really affects everything. The sufficiency of the evidence argument we made was really narrow in this case because, admittedly, there was sufficient evidence based on the testimony of DI. Had that testimony not been admitted the way it was, the sufficiency of the evidence probably wouldn't have been there to convict my client prior to his even testifying. When an accomplice testifies in this situation, especially an accomplice who is testifying as a court witness on leading questioning, the jury should be given and defense counsel should instruct on the grave suspicion jury instruction as to how a jury should view the credibility of an accomplice testimony. Here that instruction wasn't requested and it wasn't given. I submit to you that it's ineffective assistance of counsel and plain error. There is simply no justification to not ask for that instruction in this case, where the entire basis of the cross-examination and the testimony of DI was based upon his lies, his inability, his failure to cooperate with police, and his never having told the truth. He came in and he testified as a court witness. Initially, the request for the court witness was made based upon the state of Ohio not wanting to call DI to testify untruthfully. However, there was not going to be any surprise or the like, as DI had never made a truthful statement. He had never identified Mr. Soto. He had never given them any information regarding the case that was credible. The detective said we just stop communicating with him and stop investigating him because nothing he ever told us was credible. So the state calls him as a court witness and starts asking leading questions. On top of that, the state requested an instruction be given regarding immunity. And when DI initially took the fifth, he was given immunity and forced to testify with the statement that if he didn't testify truthfully, he could be indicted with additional criminal offenses. So essentially, he was testifying on leading questions with the state basically stating this is what happened, this is what we want you to testify to, and him having to say yes, or he would be subject to additional penalties. This even infected the identification of my client, and DI was the only one who identified him as being there and being the shooter. Where the state just basically said, this individual sitting here wearing this is Keith.
Well, eventually your client admitted he was there and it was self-defense. He testified to that.
Absolutely. After the state presented its case in chief, my client did have to testify, and he did admit he was there, he was the shooter, and it was self-defense. However, had these steps not been taken, there likely wouldn't have been sufficient evidence to even get to that point. Again, there's no sufficiency argument on those issues because he did testify to them.
With all the credibility issues you're talking about, the fact that the investigators said, look, we didn't talk to DI anymore because we don't think anything he said is credible, and the fact that he was testifying under immunity, with all that information, was the jury aware of all that information?
So the jury was told that he was a court witness because he took the fifth. They weren't explained as to what testifying with immunity is, how that works, what the threats or punishments against him were. And again, I think that's why it's so important, and I go back to the accomplice instruction, because this was really a case of, I guess he said in this case, there's no question that my client was the shooter. He admitted that he was the shooter. The question was, whose gun was it? My client said that DI brought the gun, that he wrestled the gun away from DI and ended up having to shoot JB because that individual brought another .40 caliber firearm with an extended mag and a giant light that he said was tucked away in a fanny pack, that the firearm was actually larger than the fanny pack, so I'm not sure how that could have been, but I regress. And my client states that he had to shoot in self-defense. The jury was clearly considering the self-defense, and again, I know that inconsistencies in verdicts don't go anywhere, but we still have a situation where they acquitted my client of the robbery, which is what DI was saying my client did, that he was there to steal this marijuana, and my client was saying, no, I wasn't, this was just a small marijuana transaction, and it turned into this firing incident. There were two DNA profiles on the firearm that my client says he wrestled away from DI. One DNA profile was my client's, he admits he was the shooter, so that's as expected. The second one was untested, and what was turned over in discovery was actually a report that stated that there was no additional DNA evidence to be tested, but that wasn't true. There was the second contributing DNA profile on the firearm, which was never tested, and there was a sample from DI, so they certainly could have had they been requested. And the state was in control of this evidence, and my client filed a notice of self-defense. That profile could have been tested, and that would have corroborated, again, my client's version of the story, or not, that DI had possession of this firearm at some point, and my client had to wrestle it away and act in self-defense. I think what he's asking for here, Your Honor, is an opportunity for a fair trial. I think in this situation, having a court witness with immunity is pretty much conflicting. The court witness is a situation where there are two different stories given, and they believe that one is true and one was false, and it allows the state to cross-examine or impeach their own witness with the truthful statement that had previously been made, especially in situations where there's a surprise as to what's testified to. DI never gave a truthful statement. In fact, on the eve of trial, before testifying, he met with the state of Ohio and again gave another inconsistent statement that wasn't truthful and wasn't what he testified to at trial. What he testified to at trial was all new. It was based on leading questions as presented by the state of Ohio. And then you add in this immunity factor and say, hey, by the way, if you don't agree with what we're saying, we can charge you with additional offenses. Even though you've taken the Fifth Amendment, you don't want to testify. The ID was certainly suspect, especially where DI did not pick Soto out of a photo lineup that he was in, wouldn't identify him previously, and then all of a sudden we come to trial and the state says, this guy right here, yeah, that's him. Oh yeah, okay. So DI, that's what leads to the identification. The evidentiary issues, again, DI was never investigated. DI leaves the scene of the offense with the body in his car, drives to his house. We don't know what he does at his house. Goes back to the scene of the offense, and then calls police with the dead body in his car from the scene of the offense, so it looks like that's where they're at. There's no investigation at any point to DI's home. There's no attempt to get a warrant. There's no attempt to search his cell phone that he just wouldn't provide with consent. And the police just basically shrugged it off and said, well, he was never really a suspect. If they believed that it was a drug deal, and again, DI originally said that it wasn't, under the law, he would certainly be a suspect for a felony murder or involuntary manslaughter or any of those offenses to that effect. There was no reason not to investigate him, and certainly that precluded my client from having access to that evidence and mounting a defense. Again, with the DNA profiles that weren't tested, there were other reports and cell phones that weren't turned over until the last minute. The jury would have had an extremely difficult time with how to weigh the evidence. There was a significant impact on how the jury would weigh that evidence, and a failure to properly instruct them how to weigh it. And that goes back, really, many of the assignments of error coupled together. The lack of the instruction on the accomplice, the immunity, and the court witness, which I've never seen before and was unable to provide really any cases as I would have liked to that kind of distinguish them or stated that they can or cannot go together. But I think in this case...
Counsel, let me just note that you're into your rebuttal time now. You're certainly free to continue for a while longer if you wish, or we'll reserve the rest of the
I'll reserve the rest of my time. Thank you.
May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellate in this case. We are asking that this court affirm Mr. Soto's convictions. Just at the beginning, I would just like to state that there is no evidence in this case that DI was an accomplice of Mr. Soto. Even when Mr. Soto testified, he testified that he was engaging in a drug transaction where he contacted DI to purchase the drugs, and then his version of events is that there was a drug deal gone wrong, but they were not accomplices. DI was the seller, and Soto was the buyer. So he's not an accomplice under any examination of the record in this case, including Mr. Soto's own testimony. So there would not be any basis to give that instruction. If anything, DI was a victim of Mr. Soto's felonious assault. He was also shot in the back, just as the decedent in this case was shot in the back. So the evidence that we have, all of it, the physical evidence, the testimony of DI, however much credibility that the jury gave to them, which was clearly a decent amount of credibility, as his version of events was consistent with the physical evidence, which included Mr. Soto's DNA being found on the trigger of the gun, which was found in the location where surveillance video showed his vehicle, which was consistent with the cell phone tower. Evidence that put Mr. Soto going from Cleveland to the Yukon Street area in Akron, and then back to Cleveland, and along the way where the gun was found, which had his DNA on the trigger, those bullets, the bullets that were found
on the DNA on the gun. Was there some other source of DNA on the gun, and was there a reason given why they could not test that source?
There was additional DNA. They said they could not determine who contributed that DNA, but Mr. DI was never considered a defendant or a suspect in this case. He was shot in the back, so there was no reason that they would have examined that. I don't know that whether there wasn't enough. It just said that they could not determine who that second contributor was. But the bullets that were found in the decedent matched that gun that was found along the highway. So, but I would like to start with his first assignment of error and a second assignment of error with regard to 290302B and his assertion that the state has the burden of proving that the predicate offense is not a violation of 2903 or 290304. And a reading of the statute demonstrates that it's not an element. It was the legislature's intention of making 290302B felony murder to be based on predicate offenses that were 1, a felony, 2, a violent felony, and 3, a felony 1 or a felony 2, and 4, when it is a felony offense of violence, that's a felony 1 or 2, that it's not one of the inferior offenses, which would be 290303 or 290304, involuntary manslaughter or manslaughter. Clearly, if someone committed an offense that was a felony, and as a proximate result of committing that F1 or F2 felony, that was not also an offense of violence, they could be charged with that inferior offense of 290304. And the jury instruction for 290302B specifically delineates that what you fill in as far as the instruction goes is just that as a proximate result of committing, and then you insert that offense, which you have already at the charging time determined was a felony offense of violence, that's a felony 1 or felony 2, and is not a violation of 2903 or 290304. So that's all you insert in there. However, if there was evidence that would establish that the person might have shown that it could be a violation of those two offenses, then the jury instruction for 290302B provides that you would instruct on involuntary manslaughter or voluntary manslaughter. So it's clear that the legislature was simply establishing what the predicate offense was and not establishing an additional element for the state to prove. If the state had to prove that a violation of 290311 is not 290303 or 290304, that is really, one, putting the jury in the seat of making a determination of a legal issue, not a factual issue. That is something that you would challenge. You could say that the indictment's defective. It charges something that is not an appropriate predicate, and that is something that the court could determine prior to trial because it is not engaging in summary judgment, because it is not something that you would have to try the case to get to the answer to that issue. So the plain language of the statute, there is no case that says that 290302B requires that the state prove that the predicate offense is not also 2903 or 29034. That is part of the phrase where the legislature has established what offenses can provide the basis for 290302B. So the state would argue that the argument with regard to the sufficiency of the evidence and the weight of the evidence as to the phrase "and not a violation of 290303 or 290304" must fail because it is not a factual determination for the jury and is not an element that the state has the burden of proving. With regard to the arguments about the jury instruction, the state would argue, one, that the defense did not prepare a jury instruction or ask for any type of a jury instruction. The jury instruction that was given was appropriate, it was within the law. It accurately set forth the jury instruction for 290302B. There's no case law that would find that that jury instruction was not sufficient. The jury was instructed generally on credibility. Certainly there were credibility issues that the jury was aware of with regard to DI, and it is completely within the jury's purview to decide how much credibility to give to a witness. So even when you have a witness who gives statements that are conflicting, here when you take his statements, they are consistent with the DNA evidence, with the autopsy testimony with regard to where the injuries were, that they were from the back. That's consistent with the version of events that the state gave. And it's also important to remember that this is not a case about identification. Mr. Soto testified that he was there. He simply gave a different version of events. So even if there was any error with regard to identification at trial by Mr. Soto, that error would certainly be harmless. With regard to self-defense, the state disproved...
At any time prior to trial, did DI identify Mr. Soto as the individual who was engaged in this?
No, and he said, he basically indicated that he was being untruthful because he did not want to have to testify in this case. So he did not, at any time before trial, identify Mr. Soto. But there is that other evidence. With regard to the self-defense, the state was able to show through the testimony that Mr. Soto was at fault in this scenario and that he did not have a bona fide belief that he was in danger of imminent death or great bodily harm. The version of events that was presented was that he, first of all, he testified to a very disbelievable fact, right, that he was going to buy 2 pounds of marijuana from someone he had not purchased from before, but someone that they had mutual person who knew this person. But he showed up with $2,000 to buy 2 pounds of marijuana and did not have a weapon, which, when you look at testimony any other case, everybody, I think, can agree that guns and drug sales go hand in hand. So that's the first kind of, statement that's out there for the jury to establish what credibility to give to Mr. Soto. He's testifying he comes from Cleveland to Akron to purchase this large quantity of drugs with a large quantity of money from someone he hasn't purchased from before, and he didn't have a gun. And then he has to come up with another version of events when the gun is found with his DNA on it and it matches the bullets that are found in the decedent. So based on that testimony, the jury certainly could find that he was not, that he was at fault in the situation, that he was the primary aggressor, and that he didn't have a bona fide belief that he was in great bodily harm or danger. The other gun that was found in the car that JB, the decedent, had, the testimony was that it was not ready to fire yet. The slide had not been pulled, so that gun was found on the floor. That is certainly evidence from which the jury can make a determination with regard to self-defense. The state would also respond to the allegations that were asserted about ethical violations. That's all speculation, that there could have been other evidence and that the state should have done an investigation into a victim on the case. That's complete speculation by the appellant. There's nothing in the record to support that, and therefore there cannot be an ethical violation by the state with regard to that. With regard to the identification, I articulated in the brief the exact situation as to when they asked Mr. Soto if that was the, when they asked DI if that was the same Mr. Soto, and we would argue, one, they weren't trying to get an identification per se, and two, even if it was inappropriate, it was harmless error in light of all the other evidence in this case, and three, there's no argument about identification. Mr. Soto says that he was there. This is a case about really who was the aggressor and whether Mr. Soto was the victim of a robbery or whether things were as the state showed, which was there was a drug sale that was scheduled, and that at the time that the two victims went to give the buyer the drugs, he was unhappy with the quality. He made a comment about, what this is, and then pointed the gun at them. When DI got out of the car, he was shot in the back. That JB was also shot in the back. So that would be consistent with the state's version of events. It would not be something that would lead to any type of indication of an ethical violation. And the state would further argue with regard to the immunity and the calling the witness DI as a court witness. The state complied and the court complied with Rule 614A with regard to calling a court witness. It does not require surprise. From my reading of the brief, they were mostly challenging for immunity whether this would further the administration of justice. And the state contends that having a witness testify about what happened clearly furthers the administration of justice. There was a person who was killed that day. There was another person who was feloniously victim of felonious assault with a serious injury. And it is certainly in the furtherance of the administration of justice to have witnesses who are present testify about those events. And if the way to get them to testify is to offer them immunity so they can't be charged for their participation in the event, that is in furtherance of justice. And again, with regard to 614, there is no requirement that there be surprise, just that there are those inconsistent statements, which there is no dispute that happened here. So if there are no other questions, I would rest on the brief.
No further questions. Thank you very much.
Thanks, Robert.
Counsel, you are ready.
Thank you, Your Honors. Addressing the point made by the state of Ohio where they indicate that DI is not an accomplice, I would state, Your Honor, DI was most assuredly an accomplice in the drug deal. All the testimony indicated my client was going to meet DI to purchase the marijuana. They met at a gas station. That DI had chosen the location. Then DI had my client, who was not familiar with the area, had never been there, follow him to this really secluded street to conduct this drug transaction. If DI wasn't an accomplice, why would the state offer him an immunity in this? Certainly, if he was involved in a drug transaction, he was an accomplice to this series of events and could have certainly been involved in the killing. With regard to the killing, the jury found my client not guilty of murder A, which is the purposeful murder. Murder B in this situation, and other states are getting away from it, admittedly Ohio is not, really drops the burden of proof from purposely to knowingly with regard to, obviously felony murder, if somebody is shot during the commission of the crime and that leads to their death, that's felony murder. This is a situation where somebody is directly shot, and that shooting leads to their death as an act in and of itself. Relieving the burden to prove purposely is really a disservice to my client. And I think that's where the additional elements come in, that it must be a felony of the first degree offense of violence, and that it must not be a voluntary or involuntary manslaughter. And in this case, there could have been provocation, and there certainly could have been an involuntary manslaughter with the killing just based on the drug transaction. With regard to the DNA on the firearm, the testimony to my recollection was that there was an additional profile on the gun. That additional profile could have been tested. It wasn't tested because there was no instruction given from the authorities that the lab test it, and had that instruction been given that DNA profile could have been tested and it would have been compared to DI. Instead, what my client received through counsel was a report that said there's no additional evidence or no additional DNA evidence to be tested. And it came out later on through trial that there was this additional profile. Even in spite of filing the notice of self-defense and the like, there was a DNA profile that could have been tested. Your Honors, if nothing else, due process requires a fair trial. If my client is guilty and didn't act in self-defense, then he would be found guilty in another trial, but he should at least be given that opportunity.
So your belief on the record is that there was nothing prior to trial that would have told your client there was any other DNA on the gun other than his?
So, Your Honor, there were a litany of evidentiary issues that were brought to the court's attention right at the start of trial and the week before, and there were additional cell phone experts that were hired. I was not clear if the DNA issue was brought to the attention at that point right before trial, or if it was at the trial specifically. I can assuredly say that it was no more than a week or a couple days before trial that anybody would have found out about this. Although the lab had known about it for the entire time. Even at that point, a continuance against my client's speedy trial rights to test something that should have been tested, I don't know that that would have been appropriate.
Or your client wasn't in the position of having to weigh, okay, I can request a separate test of this and have a final expert appointed to do that if the state doesn't want to, or wait until he was unaware prior to trial if there was any other.
There was some consideration about different evidentiary issues that my client didn't seek a continuance to look into, but I do not believe that was the DNA on the firearm, because my client had always been adamant that that needed to be tested, that will prove that DI had the firearm in his possession, at least at some point of time. With regard to the sufficiency and manifest weight arguments and the state's assertion that those are raised because my client testified, I would submit to you, and I believe I've submitted case law in my brief, that the court looks at those in regards to the state's case in chief, just like when the 29 would be made, 29 motion, excuse me. And then again, at the end of trial, if the state doesn't meet its burden to prove each and every element beyond a reasonable doubt, or if the weight of that evidence and the credibility thereof doesn't meet that test at the close of the state's case in chief, and here again, even specifically identity was not
I don't know if it's now. You're up, so if you would conclude, please.
Your Honors, we would ask that he be given an opportunity for a fair trial under due process, have this DNA tested, and have DI, if he's going to testify properly. Thank you, Your Honor.
Thank you.
Thank you for accommodating me this
No
morning.
problem. I want to thank both of you for your presentation today. The court will take the matter on the file and issue a decision in due course. The clerk of court will mail a copy of the decision to you on the day it's released, and this opinion will also be posted on the High Supreme Court website. Thank you both very much.
Thank you, Your Honor.